Right, guys, welcome back. Key knowledge 10 of Unit 3, Outcome 2. This one is on dispute resolution. And here we can see in our study design, this is the final key knowledge dot point for Outcome 2. So look, by the time you finish this one, you should have a fairly substantial set of notes covering all of this HR stuff. Look at this one here, an overview of the dispute resolution process, including mediation and arbitration. Okay. If you've done legal studies, if you do legal studies, those two terms might be familiar to you. So we're going to put them in a kind of a business management context here. Now, first off, dispute resolution. What do we mean by disputes? What kind of disputes might we be talking about? Could be pay issues, could be the enterprise bargaining process that we looked at in the previous video when we were talking about putting together an agreement in the workplace. Instead of going with an award, going through an enterprise bargaining process to come up with an agreement for the particular workplace. So that can cause disputes. It might be an issue over hours, could be personality conflicts, issues with management, some disciplinary issues, and anything else that you can imagine could happen in a workplace where it might cause some kind of a dispute. So that's kind of what we're talking about here, okay? Now, businesses have to have in place some grievance procedures and a dispute resolution procedure that all parties follow. Employees, employers, managers, whoever it might be, to resolve these issues if and when they occur. Okay. Now, grievance procedures, if you had to define that, a formal systematic process that lets employees complain about matters that affect them at work. So if you have an issue at work, you want to complain about something, there should be a procedure in place that you could refer to that shows you exactly the steps that you need to take to make your complaint, basically. That's all we're saying. Nothing particularly complicated about that. Now, a typical grievance procedure process. Now, we're kind of wheeling things back a little here because the study design, the key knowledge dot point said including mediation and arbitration. So we'll get on to mediation and arbitration, but we're going to kind of pare things back before we even get to that stage in the process. So a typical process, very simplified, might look something like this. So an employee, so if the employee has an issue in the workplace, has a complaint or something, the employee presents their complaint to management, and it might not be the employee themselves. They might have a representative that does that for them, who might actually be another employee. So first off, you present your issue to management. The issue is then discussed with human resources to see if a resolution can be reached internally. Now, in an ideal world, that's where it would end. Okay, so you have an issue, HR get involved, and without going any further, we resolve it somehow and come to a resolution that everybody's happy with, and we can, move on and get on with our lives. But if that does not happen and we can't resolve it internally using HR, then HR will refer the matter to the Fair Work Commission for mediation to occur. And if that does not work, then it will be referred to Fair Work Commission for arbitration. Okay. So step one, resolve it internally. If that can't happen, we go to mediation. If that does not work, then we go to arbitration. And that will all become more clear when we look at what mediation and arbitration actually are. So why is this important? Why do we need to have these steps in place in our business? The whole point is to deal with stuff as quickly and effectively as possible. If we've got any issues in the workplace, we've got any complaints going on or any dramas that's going to, cause tension or stress within the workplace, not a good thing for the relationship between management and employees. And that is an absolutely essential ingredient to business success. If you don't have a good, solid working relationship between the employees and the management, then it's going to be really hard for the business to kind of achieve its objective, its goals for the future. Okay. I've used Pappenhausen scoring a try there, one for Mr. Lawrence, to represent scoring goals or achieving objectives. But yeah, really, really important for to maintain this good relationships within the business. Otherwise, it's just going to be that much harder to achieve whatever it is we're trying to achieve. Okay. So the process in terms of ways in which disputes get resolved. So this is kind of referring back really to a couple of screens ago. Ideally, we reach a negotiated outcome within the business. If that can't happen, we then move to potentially a mediated outcome involving mediator, where that third-party mediator helps the two parties arrive at their own agreement. More on that when we look at mediation. And if that does not work, then we move to an arbitrated outcome. So a process of arbitration happens where an independent arbitrator, basically a court for all intents and purposes, makes a legally binding decision, which then both parties have to adhere to. So it kind of escalates in levels of seriousness, if you like, which is why ideally you want number one to happen. If that cannot happen, then you move to 2, and hopefully that resolves the issue. If that can't happen, then you move to 3, and then 3 would definitely come up with a resolution, and we look at how that would look when we look at arbitration. Now, those final 2, mediation and arbitration, generally involve Fair Work Commission. That definitely arbitration does. Mediation doesn't have to. You can actually appoint a mediator. And again, we'll look at this a little bit more in a minute, but you can appoint a mediator yourselves that is not part of FWC, but usually that's a process that a business would go through. Get FWC involved, they would put a mediator in place, and we start the process. Now, I'm just going to talk about industrial action, okay? So this is not mentioned specifically in the study design, but in case material, cases often kind of go down this route, and industrial action is mentioned, so it's worth just touching on it here a little bit and giving you a bit of an understanding of what industrial action is and what it might look like in the real world. So although it's not, like I say, it's not specifically mentioned, I think it's still worth having a bit of an understanding of what industrial action is. And it fits under the umbrella of disputes, which is what I'm kind of putting in here. So if we are talking about the negotiations of a new enterprise agreement being the root cause of the dispute that's going on, so in other words, what I mean here is the employees want a certain level of pay rise, but the employers are offering a lower level than that. This is usually how this works, or it might be around the conditions. You know, the employees want certain conditions in place for their next agreement, but the employers don't want to offer those conditions. So this is a big cause of disputes in the workplace during the process of negotiating a new enterprise agreement. So industrial action can be taken by either party to kind of further the negotiation in that negotiation process. Okay, so usually it's taken by the employees, and we'll demonstrate that in a minute, but it can be taken by the employers, but it has to be with the consent of the Fair Work Commission. So if the two parties, the employers and the employees, and again, it's usually the unions involved in this process opposed to the employees themselves. So the union cannot agree with the employers over the pay conditions for the next enterprise agreement. Then what will often happen is we just can't reach an agreement, and then one side will take industrial action to kind of further their position in that negotiation process. But they cannot do this without the consent of the Fair Work Commission. So if either the unions or the employers want to take some kind of industrial action, they have to apply to the Fair Work Commission. It has to be granted, like permission to do it must be granted by the Fair Work Commission, and then the action can be taken. You can't just decide to take industrial action off your own back, because there can be legal ramifications for doing so. So that's a really important point. In terms of what might this look like, so a strike is the most commonly known method, I guess. And a strike simply means employees just withdraw their labour and production work ceases completely for a period of time. So you might decide to go on strike for a day, a week, whatever it might be. Now, also going to point out here that you can't strike, or employees cannot strike at any time other than during the enterprise bargaining process. So employees can't just decide at some point that they're, paid off with something in the workplace and they just decide to go on strike. You can't do that. This is only a strategy that can be used as part of the enterprise negotiation process to further your position in that process. Okay. So that's pretty straightforward. And you see this on the news from time to time, employee, out demonstrating with their, we're on strike now, all this kind of stuff, hence that picture there. The second form that you might see, and this actually is often linked with strikes, the two kind of go hand in hand often, is a picket line. It's where employees demonstrate outside the premises, so they're physically there forming what we call a picket line outside the premises of the employer. And the aim of that is to deter other employees and also suppliers, if they're coming with supplies to the business, from crossing the picket line. So as you see there, they'll form like a physical barrier and they'll be trying to not let anyone cross the picket line. The word picket, by the way, obviously one T, not two like my name, comes from the French word piquet, P-I-Q-U-E-T, which is a stake in the ground, which is used to form a border, hence the picket fence, the same origins. So not that you need to particularly know that, but anyway, just out of interest. Picket line and strikes often kind of go hand in hand. Another form of industrial action is often taken. This is often taken before we get to strike. Like striking is pretty serious, completely stopping work altogether. And the problem with the strike is it's not often employees don't really want to strike because they're actually forfeiting their pay. So if you go on strike for a day, you're not going to get paid for a day. So that is not a strategy you want to be using unless you really have to. And often some of these other slightly softer approaches are used before we get to that stage. And one of these might be work to rule. So workers refuse to do anything more than the bare minimum required according to their employment contract. Now, the reality is in the world of work, a lot of the time employees are doing much more than what their contract says they have to do. That's just kind of the reality of work. So for a period of time, workers would just refuse to do all that other stuff and just do the legal minimum they're required to do as stated in their contract. And there's just an example. This one is out of Ireland. It's the only one I could find in the media. Recent times, so some nurses in Ireland were going on a work to rule. It says in there, if the union gets a mandate, and that means the mandate means they're getting permission from, I guess, the Irish equivalent of the FWC, they will start a work to rule. Passive resistance is another one. A general lack of cooperation by employees to complete tasks using various means like taking days off, causing absenteeism, or operating a go slow. Now, this is one of my favourite ones. This dates back. You can see there 2011. But this is my favourite example of a go slower passive resistance. So Qantas engineers, there was a drama over their next enterprise agreement they were trying to negotiate at that particular time. And what they did, the engineers all decided to use their non-preferred hand to do their work. So you can see in there, so maintaining the airline's planes by using their left hand only, I guess if you're right-handed, and the other way around if you were left-handed, screwdrivers, spanners and tools and that sort of thing. So they were still doing their work, but obviously if you're using your non-preferred hand, it's going to take you a lot longer and that impacts the business. So give you another example of all of this. Go back to about 2013. Teachers in Victoria, the government were not coming to the table with what the unions wanted for the teachers for the next 4 years. And we actually did, if we go back to the work to rule, so teachers actually did work to rule for a period of time. So no agreement could be made. So the union negotiated with Fair Work Commission, teachers could work to rule. And for a period of time, nothing happened outside of the core hours of school. So nothing happened in the evenings. No camps happened, because that's, again, stuff which teachers do, beyond their contract. So for a period of time, teachers did a work to rule. That actually did not work. The government still didn't come to the party. So then ultimately what happened is it moved to striking. And I can't remember how many days. It was maybe 2 or 3 days over a period of time that teachers went on strike. Then the government shifted their position somewhat. They didn't come completely to the table, but it led to a position where, the government kind of came up, the union kind of came down, and they met in the middle somewhere, and the agreement was then put in place. So that's kind of how this stuff kind of plays out. So anyway, the final one I'm going to point to you, a lockout, and I've put all these asterisks there. This is the only one I'm showing you which is actually taken by the employer. All those other ones are strategies used by the employees. This is kind of like a reverse strikes. This is where the employer or management doesn't actually allow the workers to enter the workplace to carry out their jobs. Now, again, employers don't really want to have to go there because it means, no production again happens, just like in a strike. But again, it means they're not paying the employees. So it's almost like a battle of wills. Who's going to give in first? Who's going to, come to the table in terms of lifting their expectations, or on the other side reducing them? And the whole point of this is to ultimately force the other side to kind of meet you somewhere in the middle so that an agreement can be made. So yeah, a lockout is the only one that I'm pointing out to you is actually taken by the employer as opposed to the employee. Now we're getting into forms of dispute resolution specifically mentioned in the study design, the mediation, the arbitration. So this is where, kind of skipping prior to when I talked about industrial action, if we can't reach a happy outcome internally, this is where we now start to get external parties involved in our dispute resolution to try and come to some kind of an outcome. So mediation is where an independent third party, the mediator, is appointed to support discussions between the two parties. Okay. Now, it can be a third party agreed on by both parties, the employer and the employees, but Fair Work Commission can appoint one. And like I said before, usually that's the route. It's the easiest route to take. Just get Fair Work Commission to send someone in, and they will send in a mediator. Now, with this process, the mediator assists the parties with the discussion about whatever the issue is. But the key here is the parties arrive at their own agreement. Okay, so the two parties, the mediator is there not to make a decision. They're there just to kind of smooth the process over and keep both sides on track and kind of, to mediate the conversation towards coming to an agreed outcome between the two parties. But the key here is that the mediated outcome is not legally binding. So I guess theoretically, you could, you're in a room, there's the mediator there on both sides and each side of the table. You agree on an outcome, and then you leave the room, and then one of those parties could then not stick to their side of the bargain, if you like. That's kind of an issue which we look at when we look at the advantages and disadvantages. But yeah, that's the key. So the mediator just smooths over the discussions. That's their level of involvement, but they are not involved in the agreement, and the agreement is not legally binding. So this will be sounding familiar to those of you that have done legal studies. Arbitration. So this is now, we go here if the mediation did not work and we've mediated to death and we still cannot come to a resolution. Now we go to the most serious level of dispute resolution, which is arbitration. So now Fair Work Commission would appoint this person, so an independent arbitrator. So what they do, and I said before, this is like a court case, because what happens is both sides present their arguments to the arbitrator, and then the arbitrator actually makes the final decision, just like a judge in a court case. And then that decision is then legally binding on both parties. Okay, so the decision making here is actually taken away from both parties. Both parties are just putting their best case forward, and then the arbitrator is making the decision. Now, one of the issues with this is that the employer-employee relationship might be damaged going forward because, you haven't kind of come to an agreement yourselves. Again, we get to that when we look at advantages and disadvantages. But hopefully you can see the difference between mediation and arbitration, and why arbitration is kind of the final step in the process. Because whatever happens, a decision will be made. Okay, the arguments are put forward, and then the arbitrator, the judge, makes a final and legally binding decision. And then we draw a line under it, and we all have to move on. So looking at some advantages and disadvantages of each now, as is so often the way in business management. Look, the advantages of mediation is, in terms of moving forward, it generally leads to more positive relationships because we have a mutually agreed upon decision. Okay, both parties are more likely to be happy with the outcome because they've all agreed to it. Whereas if we've gone to arbitration, the arbitrator is going to make this decision, but it might be a decision that actually neither party is happy with. So you could assume that if both parties have actually agreed themselves to whatever the outcome was, whatever the resolution was, they're going to walk away happy. Reality is, one party might be a bit more happy than the other, Might not be a completely level playing field, but at least they've both agreed to it. It's less expensive, less formal, and less time consuming than if you go to arbitration. That is a lengthy process and very, very expensive when you start to get those people involved. And also key, the process is kept out of the public domain. Once we go to arbitration, like court cases are in the public domain. If you were interested in a particular court case that happened, you can go on to the relevant website, the relevant government website, where whichever level of justice we're talking about, and find all the details and any judgments that have been made in the court system. So it's all in the public domain, and that would happen the same with arbitration. Whereas if we've stopped before arbitration, at mediation, nothing is published publicly. So I guess the idea here is airing your dirty linen in public. Okay, sometimes you don't want to do that. You'd rather keep it in-house. It might not be a good look if the public are privy to this information about these disputes going on in your workplace. So this is a way of kind of keeping a lid on it, I guess. Disadvantages to mediation, it might actually be possible for both parties to reach an agreement. Okay, so if you physically, you've done lots of mediation and you've gone back and forth, ultimately you might just never ever come to a position that both parties are going to agree to, which is why you then have to go to arbitration. The other issue I touched on before, if an agreement is made, it's not legally binding. So later on, one of the parties then might decide just to not abide by it. Okay, then you're kind of back at square one. And there can also be an imbalance of power here. I guess the employers might be in a bit of a position of power here. Kind of they hold the key. Employees might feel that it might damage their future careers if they're kind of going up against the employers, and they might kind of feel like they're being coerced into agreeing to something that they later regret. That's just kind of the nature of the beast as it is, with employers probably having a bit more power in this scenario. So there's some disadvantages to going that option. And then arbitration, the advantages here is it guarantees that decisions can be made. So whatever happens, we know we're going to get a decision out of this process. Again, final decision is legally binding, so both parties have to adhere to it. So this definitely resolves the dispute. And now the employees can't be coerced into agreeing to something they didn't want to, okay, because the decision is taken out of the hands of both parties. So it kind of removes that potential imbalance of power that you might actually see in mediation. Disadvantages, again, I've kind of touched on most of these really already. No control over the decision by either party. So both parties might walk away not actually liking the decision's been made, but you've been taken out of the decision-making equation. So it just is what it is. Again, future workplace relations might be harmed because one party is probably going to walk away happier with the outcome than the other. It's probably unlikely that you're going to walk away 50-50 here. So someone's going to walk away happier once the decision has been made. So again, moving forward, that might still cause some tension in the workplace. Time consuming and expensive, like I say, flipping around the advantage of mediation. And again, flipping the advantage to the other one, the process is now in the public domain. So once you go down this route, once it's all over, anyone can go into the relevant website and find out exactly what happened and what the drama was all about. Okay, so that is all the content. So just worth, I think, for this one, just summarizing what we've gone through here to kind of review and to make sure you understand the process we've gone through here. So first off, we looked at what kind of disputes we're talking about. They're just some examples, and really that could be anything. Grievance procedure. So kind of, I said, peeling it back to before we even get to mediation arbitration with those grievance procedures, and the idea that before we even get to mediation arbitration, we want to ideally come to a resolution whenever there's a dispute in-house, without involving anybody else. And why is that important? To maintain workplace relations moving forward. Touched on industrial action, which was kind of a bit of an aside, but it's relevant to this area because it's to do with disputes. And again, bear in mind, it can be taken both by employees and employers. We looked at one example of the employer taking industrial action and a few by the employees. And then we got on to mediation and arbitration, where in questions, you need to describe both processes and then think about, you discuss them, which you've got the advantages and disadvantages there, and also compare them, so legally binding versus not legally binding, so on and so forth. So you should have enough information from this video to tackle any questions that you see within this key knowledge dot point. That is it for this particular one, so key knowledge 10, but it's also it for the entire outcome to HR management. So I will see you in the next video in a little while, which will be starting on the final outcome for Unit 3, which is on operations management. I will see you then. Cheers for now.